Discharge of the contracts. Discharge of the contracts means that both parties terminated of contract to a relation to a contract. In other words, a contract discharge when the right and obligation created by it come to end. A contract may be discharged by performance, by agreement or consent, by frustration, and the last one is by breach of the contract. Discharge by performance. Both parties who get into the contract has successfully performed their promise. If the contract have a time stated in the contract, both parties need to perform by according to the time. For example, the purchase of a car time for us to pay in installment such as 10 years. We execute the contract indirectly. We perform the contract after 10 years after payment. There is no time fixed. The contract need to be performed within reasonable time. For example, within 1 month period. For example, by performance, Nina agreed to sell his bag to Intan for Rm300 ringgit and Intan has agreed to pay for the bag. Is that means Nina and Intan has successfully performed their contract. The contract is categorized as being discharged. Discharge by agreement. Both parties get into a contract, agrees not to perform the contract. By agreement can be replace old contract with new one. By rescission, by alteration of contract. For example, Ikmal has sold his book to Shauki at Rm60 ringgit, but they changed their mind to not buy the set and sell the book. It is because of the agreement by both. Their contract has been discharged.
Discharge by frustration have two types. First, when the contract itself impossible to be performed. Second, become impossible to be performed after it has been made. It occurs when unexpected event occurs into the contract. We have 5 situations when the contract that has been made cannot be performed. First, destruction of subject matter. Second, there is supervening event. Third, death or personal incapacity. Fourth, change in the law. Last but not least, effect of law. For example, Ahmad has just married his wife. He wants to have a feast and need a tent for the guests. He rented a tent instead of catering. An agreement has been made between his and the catering. However, on the day of wedding, the tent was damaged by a strong rainstorm. The both parties cannot sue each other. It is because the contract was void due to the destruction of subject matter. Next, we move to discharge by breach of contract. The promiser does not fulfill the promise or breaches the obligation imposed by the contract. When the party to the contract without lawful excuse does not fulfill his contractual obligation or his own act make it impossible that he should perform his obligation under it, can terminate by performance, second agreement, Last but not least, impossible to perform.
Does mean by remedies is the manner in which a right is enforced or satisfied by a court when some harm or injury recognized by a society as a wrongful act is inflicted upon an individual. Furthermore, when these remedies happen, the non-defaulting party may claim one or more of these: A. Breach of contract, B. Damages, C. Specific performance, D. Injunction, and the last one is quantum merit. So here we go to the first following, which is discussion of contract, where a contract is void by a reason of mistake, not based on fact of law. So the example is an insurance company can cancel your policy if discovers that you intentionally list false information on your application for insurance. Secondly, about remedies is damages. Damages are awarded for breach of contract. Generally, the purpose of an award of damages for breach of contract is to compensate the injured party. Types of damages is A. Damages arising naturally of ordinary damages, B. Damages for any special loss sustained, and the last one, C. Liquidated damages. First of all, A. Damages arising naturally or ordinary damages, meaning here, naturally occurring or ordinary damage. This is damage for any loss or damage caused thereby, which is naturally in accordance with the ordinary nature. Caused by the breach, as a case in point, 4th of December 2017, Kampung Bulu Hilir Paddy Group Cik Aziz Cik Hamid, 44 years old, showed that damaged paddy crops were flooded in Kampung Kasik, Permaisuri. Special damages for any special loss sustained. The terminology and classification of special damages is one such term that can produce uncertainty depending on the jurisdiction and context in which it is involved. For example, if a person was injured in an accident, the victim could seek damages that would cover medical expenses, damages to the vehicle, and the loss of earning now and in the future. This would be classified as special damages. Last one is liquidated damages. Liquidated damages are meant as a fair representation of losses in situations where actual damages are difficult to ascertain, such as if you do not receive a new house within the promised period, you will have to bear the losses of ringgit money. In your SPA sale and purchase agreement document, there is a clause called liquidated or ascertained damages that allow you to claim damages. Other than that, also having a type of damage. There are substantial damages, nominal damages, and the last one is exemplary damages. My last part to elaborate is specific performance. Specific performance is a type of remedy in contract law which is discretionary in nature. Specific performance is equitable relief given by the court to enforce against a defendant the duty of doing what he agreed by contract to do. For instance, specific performance is usually ordered in cases where an award of damages would not be enough to remedy the situation, such as case involving the sale of real property. Specific performance is ordered if the court decides that it is an appropriate remedy for the situation at hand. That's all from me. I am passing to Dayana to finishing the other remedies part. Thank you.
Now I will continue to present my presentation, which is injunction. What is injunction? Injunction means injunction is a court's order to restrain the doing, continuance, or repetition of some wrongful conduct which is against the contract. There are two types of injunction, which is temporary and perpetual. Temporary injunction or interim injunction are such as to continue until a specific time or until the further order of the court. They may be granted at any period of suit and are regulated by the law relating to civil procedure. And the perpetual injunction or permanent injunction is a perpetual injunction can only be granted by the decree made at the hearing and upon the merit suit. The defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act. The example situations is when a contractor refuses to finish building the hotel new property on the date given. The hotel can request the court to apply the mandatory injunction to the contract to finish the work. And the last one is quantum merit. Quantum merit, which literally means as much as he deserved, is a claim for reasonable remuneration for work done or services supplied under the contract in the event of breach of the contract. For the examples of situation is where one party refuses to perform the contract. The relevant case is Plaintiff v. Colburn. In this case, P contracted with C to write a volume of ancient armor for a periodical called the Juvenile Library for a fee of $100. After P had written part of his work, C abandoned the periodical. The contract could not therefore be completely performed. P sued C. This was held that C has repudiated the contract and P was entitled to treat it as discharged and recover a quantum merit for the work he had already done.